Mr. Speaker, sir. I want to be very specific on my submission on this culmination. Now, as the explanatory note suggests, that the supplementary demand is required for the expenditure to pay the fees of the lawyers. Therefore, I would like to know from the Honourable Minister the details of the expenditure, as in the names and the cases for which the fees has been charged respectively, and in which courts. Now, I have with me an office memorandum dated 20th February 2019, number LRB 13/2002/PT/170, which fixes a rate for the government advocates appearing in high courts. A. Appearance fees per case, either adjourned or heard, for senior government advocate or additional senior government advocate, additional government advocate, and panel government advocates, limiting to 3 number of cases per day. The rate of fees is fixed at rupees 1,600. And B, for drafting fees per case for senior government advocate, additional senior government advocate, or government advocate, or additional government advocate and panel government advocates. Number 1, for substantive petitions, rupees 2,500. Number 2, for miscellaneous application, replies, written submissions, etc., is rupees 1,500. Now, this is for the appearance in the High Court. And for the Supreme Court, I have additional office memorandum dated 7th February 2019, number LRB 50/2017/19, which says that the Government of Meghalaya is pleased to fix the rate of fees for panel advocates appearing on behalf of the State Government of Meghalaya at the Supreme Court of India, National Green Tribunal, and other benches, courts, tribunals are as follows. Number 1, for appearance and argument fees at Supreme Court, the proposed rate fixed is rupees 7,000 plus 10% clerkage per case. Number 2, appearance fees at National Green Tribunal, other benches, courts, tribunals, rupees 7,000 plus 10% clerkage per case. Number 3, conference and briefing, rupees 14,000 per case. Number 4, written opinion, filing counter affidavit, drafting application on behalf of different departments in the state government, drafting reply and comprehensive affidavit, rupees 5,000 per case. Number 5, appearance in various courts in the state, rupees 8,000 per case. Number 6, travelling allowance as entitled to grade 1 officer of the state. Now the proposed rate, it says, shall be entitled to perform the journey by air both for inward and outward. Now these are the rates which are very specifically fixed for the High Court and the Supreme Court. However, for the district courts, I don't know whether the rates have been fixed in such a specific manner. So I would like that clarification. And also, we know and we are aware that there are so many cases in the district courts, and sometimes lawyers from outside are also brought forth to appear. So we would like to know if the lawyers are being brought from outside the state. And also we would like to know whether the lawyers from the state itself are given more preference by the government to appear in the high courts as well. Now, number two, this is number one. Number two is that regarding the 10% of the state share, which is required to be given as an equivalent to the 90% central share, we would like to know the details of the schemes. Which are the schemes for which this has to be dispersed, the 10%? Thank you, sir. Chairman, sir.
Yes, another one. Mr. Rupa.
I would like to support the petition moved by Honorable Member from Ampati, Srimati Miyani Deshira. Just in a nutshell, in the recent past, what we have been observing is that for the purpose of appearing in the courts to deal with the litigations on behalf of the government and on behalf of number of departments and also other entities under the government. Entities means government undertakings. Most of the cases are being appeared by lawyers from outside. This is, I think I heard well, the mover of the cut motion as well. And so I would also like to stress on this particular issue because in the past we have given abundance of opportunity for our own lawyers. And it is precisely for this purpose that we have also tried and persuaded Government of India to have our own High Court. Now, look at the kind of cost which are avoidable. Bringing lawyers from outside, paying for the whole travel expenditure, and also accommodation. And I have the inputs that accommodations are also given in the five-star hotel. Look at the quantum of expenditure which is avoidable. So in this regard, I think the law department has to revisit this and see that these preventable outflow of resources from the public exchequer is prevented to an extent possible. And at the same time, we must aware that this platform must be given to our own lawyers so that they will be able to climb their career path in the right earnest. And that is the platform. Where else will they get? And at the same time, I would like to draw the attention of the minister in charge. If some lawyers are being brought from Delhi, don't they have cases in Delhi? If they are good lawyers, I mean, from the professional perspective, I am not doubting, but it's a common sense. If somebody has hundreds of cases in Delhi, will he have time to come to Shillong? Therefore, we can understand the level of professional efficiency vis-a-vis the professional efficiency of our own lawyers. I don't want to demean their professional competence, but it just is a common sense. Therefore, if we ask any lawyer from Shillong to appear any case in Tura, what is the reply? Good lawyers have, their hands are all full. They can't go. They can't afford time. This is how lawyers are. Therefore, I don't understand how we are getting so many lawyers from outside who have the time to come to Shillong, fly and stay and then appear on behalf of the government as lawyers to represent the government in the litigations. I think this is required to be really sort of investigated by the department itself, because giving complete, the free hand to AG can misuse. Therefore, it's the onus of responsibility lies with the government to regulate these tendencies. But that's why, even though this matter is, this demand is usually, I have not seen so many cut motions being tabled when we pass the grants for demands in respect of law department. But this time we thought it is appropriate and proper. I think it's better than we don't dwell too much on these, but then I think samajhdaro ke liye isarai kafi hai. So I hope the minister in charge will take cognizance of this concern. I don't want to be much more elaborative on this issue, but I request the minister in charge and the government to take cognizance of this issue and correct things. Thank you, Mr. Chairman, sir. With these few words, I support this cut motion.
Now I will call upon the minister in charge to reply.
Honorable Chairman, sir, at the very outset, let me thank the Honorable Member from Ampati, Madam Miani, for raising this cut motion to discuss the expenditures related to fees of lawyers in the central sector, centrally sponsored intervention programs. I thank the Honorable LO also for expressing his thoughts on this matter. Since the Honorable members were direct in their queries, maybe it would be appropriate for me also to dwell specifically on the issues raised in this August House. Sir, the cut motion has been presented before this August House in as logical a manner as possible. Seasoned leader of opposition, having looked at history and has also opined and noted that this is a rare occurrence. I would like, Chairman, sir, to set aside few observations made in a bid to make it appear like the government will bypass law, will bypass convention and practice, and will bring in lawyers at their whim and fancy. Nothing happens on whim and fancy, sir. Everything is as laid down by procedure. Certain cases, because of the complexity of these cases, maybe there have been recommendations made by the law department for the bringing in of an expert of a particular nature to handle and fight for the government in certain cases. But as a practice in the district court, sir, there has been no instance, to my knowledge, where we have deviated from the practice and convention of firstly ensuring that sons and daughters of the soil of Meghalaya are allowed to grow in their career in this beautiful state. That aspiration I have to set aside. It is incorrect to infer that there is any vested interest of any nature. So this demand number 2, sir, is a demand that has two components. One component refers to the centrally sponsored schemes in regards to projects of district courts, which include construction of district courts and subdivisional court buildings at different places, as well as scheme for getting the establishment of different statutory special courts. Sir, the department is also entrusted with the administration of public prosecutors, including additional public prosecutors, assistant public prosecutors in the matter of grant of retainership fee to standing counsels, both civil and criminal, as well as paying remuneration of additional PPs and reviewing their fee structure from time to time. The fee structure, sir, whether it is for the district courts, the High Court, or the Supreme Court all function within parameters of recommended norms. Nothing, no indication whatsoever should be there that is indicative of the fact that we have gone out of convention. So the businesses under the Law Department of the State of Meghalaya include several components. I understand that questions were specific, but to reply to the questions, we need to also clarify what are these areas where funding is required. Number one, the administration of justice itself, the appeals against acquittals, law reforms, advice on legal matters, appointment of judicial officers, criminal and civil laws and its procedure, law officers, supervision of government litigation, drafting of bills and statutory rules and orders, appointment of public prosecutors, additional public prosecutors, government pleaders, assistant government pleaders, and the engagement of government counsels in Supreme Court and High Court. So this demand was specifically to ensure that pending bills of all of the legal fraternity in the discharge of these 11 duties is put up to date. We have pending bills as old as 1718, as old as 20, 21, 22, and all of these payments are as per procedure and conduct of business, nothing out of the recommended norm. We have district courts in Secretariat, Mairang, Nongstoin, Amlarem, Sora, Ampati, Maukerwat, Dadengre, Nongpo, Resubelpara, Shillong, Jowai, William Nagar. Sir, the grand total of these TEs amounts to 40 crores 27, 4 crores 27 lakhs 1,560. I have all the names of all these officials whose payments remain pending. In Secretariat alone, sir, 19 lakhs 98,000 199,82,148 is the outstanding amount. We have to clear these bills. Go to Mairang, one of the youngest districts that has been formed. We already have 67,344 pending TE for Ms. B. Karkarang, SDC Mairang. In Nongstoin, we have 5 lakhs 90,000 590,9532 is the amount. Name by name, all of these have meticulously been compiled. We want to release these payments of all of these workers who are dependent on the government for at least the processing of dues for them. In Amlarem, we have 449976. In Sora, we have 244,496. In Ampati alone, there is a pending due of 1820250. In Maukerwat, we have 1572640. In Dadengre, we have 714580. In Nongpo, we have 178080. In Nongpo, we have 338610. In Resubelpara, we have 772650. Shillong also we have 835392. Jowai we have 499181048, and in William Nagar we have 325508. These are all the pending dues of these officers who work tirelessly to fight for justice and the government. And hence, I believe that now there is clarity as to why we have proposed. I seek the collaboration and cooperation of the members. So with regards to the second component of the demand, the centrally sponsored scheme, sir. Till date, 128 CSS projects are being implemented for infrastructure development of judiciary, and the total cost of this is 454.50 crores, out of which CSS release amounts to 177.86 crores and 10% state share being 19.76, which has been utilized. An additional amount of 105.94 CSS and 11.77 is required for execution of the aforesaid infrastructural projects of the judiciary. From the financial year 2024 to 25 till date, state government has been able to utilize 43.76 crores inclusive of the 90% centrally sponsored scheme share over and above the 16 crores earmark released per year from the state of Meghalaya by the government of India. This indicates we have got more funds released over and above the earmark shares due to good performance, and also showing the state government's effort of prioritizing the development of the judicial infrastructure. Sir, we have approximately, I had asked the officers, I may be wrong a bit, but I think this morning I was informed that we have about 139 lawyers in the district courts alone. And hence, sir, I would like to inform the Honourable Member and the Honourable LO that the cut motion moved against the supplementary demand amounting to 4 crores 2,71,560 pertains to the payment of the e-bills of the advocates of the district courts, as there was insufficient fund in the budget provision, and an amount of 20 lakh was to provide 10% state share corresponding to the 90% central share amounting to 1.80 crores, being the fund released by the Ministry for the Development of Judiciary. Sir, if the honourable members so wish to also be privy to all of these interventions for administration of justice and taking justice closer to the doorsteps of citizens, I am willing to lay this on the table of the House so that there is complete clarity. And I reiterate that the government will not engage any legal expert without due procedure and necessary sanctions as per law. I hope I have made my stand clear. I understand, sir, that there is always doubt when we bring an efficient AG to the state of Meghalaya. Sir, I must place on record our gratitude to the AG for the commendable efforts put by him and his team to ensure that the government of Meghalaya is protected to the hilt in any matter that is brought to the Honorable Supreme Court as well. I reiterate We will handhold sons and daughters of Meghalaya in our efforts. And while we do not have the necessary quality of expertise, and while we are giving an opportunity to our citizens to better themselves and understand the legal dimensions of our judiciary system, we will have to depend on experts on especially very specific cases. With these few submissions, I beg the mover of the motion to kindly withdraw the cut motion proposed so that we may go about in the business of the administration of justice for all. Thank you, Chairman, sir.
Thank you. May I know the mind of the mover as to whether they will withdraw the cut motion?
Before the mover of the cut motion indicates his mind, I would like to just briefly relate to the submission I made vis-a-vis the reply of the Honorable Minister. Now, the reply of the Honorable Minister is self-explanatory towards the concern that I have expressed, and she has vindicated my concern. My concern, indirectly what I have said is, we all know that every year this August House do pass the budget, and the demands of every department, including law department, for this purpose of payment of fees to the lawyers are also passed. Now, if the pending bills of these district lawyers, lawyers engaged in district courts, have been there, have been unpaid since as far as 17-18, it itself is a self-explanatory of the need to see that our own lawyers are paid also. Our own lawyers are also paid. Now, every year the fund is there. How was the fund utilized? That means substantial amount of this fund is being utilized for payment of fees of the lawyers who are brought from outside. It is reflective of this. Minister may present all these expenses as to how much has been paid to the lawyers. That will be giving us the clarity as to how much. Now, we have different categories of lawyers. Lawyers who are appearing before the High Court. Lawyers who are appearing before the district courts, yes. Lawyers who are appearing before the Supreme Court. So therefore, my point is that if we have to take care of our own sons and daughters of the soil who have chosen to take this profession as their career and contribute for the purpose of making our judiciary system, administration of justice, more vibrant and robust, and be part of the whole process. Therefore, my point is that the minister in charge may examine this part. You may examine. I have given an opportunity for the government to examine. It is a fact. Please give the comparative expenditure already incurred in as far as the payment of fees to the lawyers are concerned. I do not say that it is illegal. It is legal. It is insulated by weaponizing the legal system and the convention. That is what is dangerous in democracy. We can always insulate anything, whatever we do, by legalizing the procedure. It is an art. I know that art is with the government. I have run the government for so long, so we know how to insulate anything of such. But that here the issue is, if this is happening, can we, to some extent, slowly create an enabling environment for ensuring that that outflow of huge amount of fees which is going for others can, naturally when flight expenditure, it is additional. Stay in the hotels, it is an additional expenditure, preventable, avoidable. Therefore, our question is, every single paisa that we spend from public exchequer, can we minimize as far as possible? Because every paisa counts, it belongs to the people. With these few words, I would like to reiterate my stand and urge upon the minister in charge to look at the whole details and make available all this expenditure which has been somehow incurred in respect to the payment of fees to different categories of lawyers. Then we will know how we can recorrect and redirect. Thank you, Mr. Chairman, sir.
Yes. Consensus, please.
Honorable Chairman, sir, points
Noted.
brought forward by the Honorable LO are being noted, obviously, but my point here is I reiterate, we cannot induce this doubt in this august house that we are spending unnecessarily. Yes, agreed, we will review, we will look at what else do we need. We now probably have to focus on training programs, we have to focus on various interventions which will build our own legal fraternity. But sir, let me assure the Honorable LO, through you sir, that we are committed to bettering and increasing opportunities for our own people. And we will do it, though it may take time. Sir.
Yes. Please, man of the mover.
Mr. Chairman, sir, I would like to thank the Honorable Minister for speaking at such detail, giving us all the information. I think we have gotten all the clarifications from the Honorable Minister. Therefore, I'd like to withdraw the cut motion.
Thank you. Since the mover has withdrawn the cut motion, now let me put the question before the House. The question is that grant number 2 be passed. Those who are for the motion say yes.
Yes.
Those who are against say no. The yes, sir. The motion is carried. The grant number 2 is passed.